I'm Jen Shaw. We spend our days helping employers sort through messy workplace situations, often in real time and often with a lot on the line. On this podcast, we'll walk through those issues, what's coming up, what actually matters, where employers get into trouble, and what to do next. No theory, just practical guidance you can use. Before we start our topic today, which is going to be not as sexy as some other topics, but still important, I want to remind you that we are sponsoring a complimentary webinar on June 2nd. Joe Beachboard and I, from Employers Lawyer, will be talking to all of you about how to conduct an effective investigation. It's called Getting Investigations Right, a California Employer's Playbook. We're going to talk about how to scope the investigation, how to conduct effective interviews, how to make solid factual findings, and how to prepare reports that actually hold up. We're also going to point out for you a couple of the traps that you might fall into. There's going to be live Q&A. All you have to do is go to employerslawyer.com/investigations and sign up there. Again, no charge. All right, thanks everybody. Let's jump into our topic. Okay, cell phone reimbursement. Why in the heck would we spend 20 minutes or 15 minutes on cell phone reimbursement? Here's why. A couple of weeks ago, there were something like 8 or 7 new lawsuits filed against California employers for cell phone reimbursement violations, right? For claims that people were not properly reimbursed for cell phone use. So I think it's a topic that is a hot one and one that we need to talk about. And it's also one that might surprise you in terms of how you can deal with it, okay? So one of the interesting things about reimbursements is they are one of the most frequently missed compliance issues in the wage and hour area. The exposure, of course, can result in class claims, class actions, also PAGA, Private Attorneys General Act claims. The interesting thing is that you have to reimburse employees even when they don't submit their forms on time, even when, for example, in the case of a cell phone, they have an unlimited plan. And you might be thinking, why do I have to reimburse them? Their plan is $99 a month, all you can eat. So what does it matter? And even when they barely use it, you have to give some sort of compensation if you are requiring them to use their cell phones for work, okay? Now, where does the law come from? This is Labor Code Section 2802. Employers are required to reimburse employees for their reasonable and necessary expenses related to work, all right? This means any expense that your employees have that has anything to do with their job, right? They're traveling somewhere, they had to buy a piece of equipment, whatever it may be. Now, it is not personal things like my dry cleaning bill or the toothpaste I'm packing to go on my trip, right? We're talking about expenses that are work-related expenses, right? Things that they have to do for work. Now, you have to remember that one of the basic concepts in California employment law is that we as the employer cannot shift our business expenses to employees. So this is like, for example, if you have a bonus program and you say, okay, I'm going to give you a bonus that's based on your productivity, but I'm going to subtract from that bonus the amount of money I pay you. Okay, well, the amount of money you pay me is a business expense. So what you got to do is reverse engineer it, right? And just figure out, okay, you lower the percentage so you don't have to make a deduction, right? Anytime you're in California and you're making deductions from someone's compensation, it's likely not going to fly. So the key question under Labor Code Section 2802 is whether the expense was necessary to the job. Okay, and there's a really important case here called the Cochran versus Schwann's Home Services, Inc. case, all right? And in this case, you know, Schwann's, they're these, it looks like an ice cream truck. They drive around the neighborhood and they sell things, but not just ice cream. They do sell ice cream, but they sell like frozen pizza and frozen burritos and that kind of thing. Milk, they have fresh milk. Okay. So in this case, these drivers are told, bring your cell phone, because if Mrs. Jones on Apple Street wants to add an extra pizza, we've got to be able to call you to tell you to give her an extra pizza. Okay. So the drivers got together and said, hey, wait a minute. You're requiring us to use our cell phone. So you're going to have to pay for that. You're going to have to reimburse us. And Schwann said no. So they sued. And the court agreed with the employees. The court said, look, you have to be reimbursed for a reasonable percentage of your cell phone bill. Why? Because they were required by the company to use their phone. The company wanted to make sure that they could reach those drivers when they were on their routes. So when we talk about work use, first of all, what are we talking about? Calls, text messages, emails that you want them to look at for work. Any apps that are required for the job, like Teams or Slack or some sort of scheduling app. If you're requiring multi-factor authentication for anything, this is kind of a sleeper issue, by the way, and they have to use their phone for that. Any after hours availability expectations, all of this is going to be counted as use for their job, right? Now, what mistakes do we see employers make? All right. The reason there were so many lawsuits that were filed a couple of weeks ago is because a lot of employers don't do this correctly. And we see patterns, right? When one large employer gets sued, it ends up on the radar of a lot of other plaintiffs' lawyers, and then they go after people for the same thing, go after other employers for the same thing. So I fully expect that we're going to see a nice batch of cell phone reimbursement cases over the next couple of months. So, first of all, if you owe them reimbursement, you cannot refuse to reimburse them because they didn't submit the form. You can tell them, I need proof of your cost, or I need you to acknowledge this document. But if you don't do it in 30 days or whatever the time frame is that you put in your policy, you can't say, okay, employee, I'm not going to reimburse you. I know you had a business expense, but you were too late turning in your form. That's not going to work. The unlimited plans, that doesn't work. You still want them to have a cell phone. So there's still going to be some cost associated with that. Now, I know everyone and their brother has 1 or 7 cell phones, right? Everybody's got a phone. So it's odd to think of this as, okay, do I really have to pay for someone's cell phone? I mean, are they really not going to have a cell phone? Not the way Labor Code Section 2802 works. The other thing that you know from prior podcasts is that in California, we don't recognize the concept of de minimis, a little amount. We have to pay for even de minimis time, and we have to pay for even de minimis expenses. So I don't care if you have a part-time employee who works an hour a week. If they're using their cell phone for business, you've got to pay for a portion of their bill. How much? Well, hold tight on that. It has to be reasonable. We'll talk about that in just a minute. What do you always have to have when you have practices like this? A policy. You must have a policy explaining how you're going to reimburse them, what documentation they have to submit. If you are not going to allow them to use their personal phone, maybe you have some reason that you'd rather have them use a company phone, then you have to put that in writing. Do not use your personal phone. Now, there are actually 3 ways or 3 approaches that you can use to reimburse your employees. The first one is what we call actual expenses, right? So you look at the employee's bill and you pay a portion of their actual bill. This is what the court suggested in Schwann's. In the Schwann's decision, they said they didn't like the idea of a flat fee. I think you're okay on the flat fee as long as it's reasonable. $5 or $10 is not going to cover it, folks. It just isn't. And if you're going to do it this way, you should require documentation. So you're saying, give me a copy of your bill. I'm going to pay 20% of your bill, or I'm going to pay 40% of your bill. Okay, the other way to do it is what we call a reasonable stipend. And this is actually the most common way. This is where we give them a flat monthly amount, and it has to be reasonable, and it has to be tied to their expected use. So if you know that most people have about $100 a month cell phone bill, and you want a full-time employee to be using that phone, you got to pay him at least $50. I mean, you just do. You're not going to get away with paying them much less than that. And you're basically stepping over dollars to pick up pennies, right? It just doesn't make sense. If you've decided you want them to use their personal cell phone, you've got to give them a reasonable reimbursement. We think that's about $50. The other option is, as I just sort of intimated, you can provide the phones. That, of course, eliminates the reimbursement issue, but it creates all sorts of other hassles with administration and what happens when somebody loses their phone and what are you going to do about it? So a lot of people don't do that. Now, I told you that the second option, the stipend, the flat sum amount, is really the most common. How do you make that defensible? There are a couple of things I want you to think about. It should be based on a reasonable estimate of the work use for that device. So that means your part-time people should not get the same amount as your full-time people. You want to show that you thought this through a little bit. You're going to apply it consistently, whatever that number is, and you're going to review it periodically. It also shouldn't sound arbitrary, like, I don't know, let's give them $20. I mean, that's good enough. No, let's think it through, right? Let's do a little chat GPT or Google search. How much is the average phone bill, which I did before this podcast, and it was $56.12. I don't know how they got that. It was like a CPI thing, some consumer price index. But if you're going to require them to have a phone, you've got to pay more than, $5 or $10. Okay. So it can't be arbitrary. Now, a better approach here is to say, okay, I'm going to pay role by role. Like, let's say I know my regional managers are on their phone 23 hours a day, but my non-exempt employees rarely need their phone, if ever. Pay them different amounts. That is going to make it more defensible than just giving a flat fee. I know it's more work, but remember, all these plaintiffs' lawyers, they've sort of wiped out the low-hanging fruit on the labor code. So now they're going for the tougher stuff. So you've got to be ready for that. And the reimbursement cases are coming. If you're going to do a policy, you want to make sure that there's a clear statement that the employee is going to be reimbursed for their business use. You're going to explain how it's going to work. Are they getting a stipend? Are you paying their actual expense? What's the process for submitting expenses if you need them to do that? The most important thing here is that your policy actually reflects your practices, right? So what I want to make sure you avoid in your policy is don't create a situation where you're discouraging reimbursement. So, don't include something like, we're only going to pay you if you really use this a lot or you demanded to be reimbursed. Don't do that. That's the key for your policy. Now, if you're going to go with, I don't want you to use your cell phone, couple things you should know. First of all, if you say it, you got to mean it, all right? So if you're really going to say no one should use their personal cell phone for their work business, then you got to say you're not doing it, and that means nobody does it, right? So your policy needs to say things like employees are not required or expected to use their personal phones. No work communications will be undertaken on personal devices. We don't want any of our employees to have after-hours contact via their personal cell phone. And then you're going to want to describe you don't need a cell phone because we have whatever your system is, right? We give you walkie-talkies or we give you whatever we're giving you. Okay. Now, the risk, of course, of one of those no-use policies is that managers say, hey, listen, I know that's the policy, but dude, I got to be able to get a hold of you, so make sure you have your phone on you, right? Or employees just want to check their email on their phone. And you don't have something clear in your policy that says, we don't want you checking your email. Don't forget about the multi-factor authentication issue either. Maybe you don't expect them to use their phone, but do they have to authenticate their fingerprint or something when they come in through security by using their phone? If so, you've just triggered reimbursement obligations, right? So here's your compliance playbook, folks. First, decide your model. Are you going to pay a stipend? Are you going to pay actual expenses? Or are you going to require company phones? Align your policy with reality. Make sure you train your leaders, your managers and supervisors, so nobody is texting on a personal phone when they're not supposed to. Make sure you audit what's really going on. At least once a year, you figure out how much cell phone use do employees in each job or title actually have. What is their use? And then make sure that you are not doing any of those things that we talked about a few minutes ago. You're not saying, well, they have a flat fee plan, so I don't have to pay them, or it's minimal use, I don't have to pay them. Be sure that you have a thoughtful policy that is fair and reasonable. That is how you will avoid liability in this area. Okay? So everybody, before we wrap up, just a final reminder about getting investigations right, a California employer's playbook. That webinar is June 2nd. All you have to do to register for it, it is completely free, sponsored by Employers Lawyer. Go to employerslawyer.com/investigations and you can register there. Space is limited, so get your spot. Make sure that you register as soon as possible. And Joe and I will be there on June 2nd. Everybody, thanks so much for joining me today. I can't tell you how much I love doing this podcast and getting to see you and talk to you. I met one of you at the airport a couple weeks ago, which was super fun, who I didn't know before. And they heard my voice and said, oh, I think that's Jen Shaw. And sure enough, it was. So it was very sweet. So anyway, you guys, thank you so much for taking your time with us. Go out and have a great day. I'll see you next time. Shaw Law Group, we solve workplace problems. Real-world guidance for real workplace decisions. The Workplace Wake Up podcast is produced for general educational and informational purposes only. The views expressed are those of the speakers and do not constitute legal advice or create an attorney-client relationship. The law is complex and constantly changing. Therefore, you should contact an employment lawyer in your jurisdiction for advice regarding your specific situation.